Welcome, everyone, to Gracefully Graying. And today we are excited to have once again Steve Malach, attorney from Lipson Neilson, the law firm, multi-state law firm, join us as we discuss, ready, are your financial affairs in order before you die? So welcome, Steve. Good to have you.
Thanks for inviting me back. Good to be here.
Yeah. So I know, you've joined us several times, and you've talked about estate planning before. And this conversation's kind of really pinpointed. It's like kind of an urgent, you really need to get your affairs in order and think about what you're doing with you and your family before something happens, correct?
Correct.
Okay.
Taking action ahead of time saves problems later on.
Right. Okay. Well said. All right. So just briefly, what are the basic elements of an estate plan?
When you contact an attorney, you'll find it involves two facets. One is, as you would think it would be, trusts, wills. The other part of it that sometimes clients neglect is what I call living estate plan issues, powers of attorney, medical advocates. These are just as important as the documents that would be needed when you pass away.
Okay. So this obviously pertains to family members, not just seniors, but their kids who might be in their 50s, 60s, 70s. All right. Tell us, should a 50 and over person, no matter what your age, have a revocable living trust? And what is that exactly?
Everybody should have a living trust. You can debate that, but I firmly believe that, having handled thousands and thousands and thousands of probate estates and having prepared thousands and thousands and thousands of estate plans. A trust is a contract with yourself. You are the creator of the contract. That's called a grantor. You are your original trustee of your own trust. You are also your first and primary beneficiary of your own trust. You make an agreement with yourself. You're the only one that actually signs it. Well, the lawyers will sign off and there'll be a witness and a notary, but it's a self-fulfilling prophecy that you create for yourself. It has the other advantage when you become sick or when you pass away to having your spouse or whoever you're with take over and handle your affairs while you're alive, and to the extent needed after you pass away, to pass them on to your wife or your children, charity, or whoever your beneficiaries are. And it's done simply by retaining counsel, making sure the document is solid, make sure it affects what you want it to say, signing it, and then you're all set. You can do it when you're young married and have young children, where you're focused on something else, as opposed to in your 50s, 60s, 70s, or beyond, when your focus is on other life issues.
Okay, so that makes sense. In other words, yeah, like you just said, you can do that at any age, and you really do need to have an attorney look at it, right? This is not something you just do by yourself.
Can prepare it, because here's some of the things that some lawyers or online kits or something don't explain to you. A trust is like a container. It's an empty box. When the lawyer makes the contract, they hand it to you. It's empty. It only is applicable to, the trustee only has jurisdiction over those things that are in the name of the trust. And by that, I mean changing the title on the house, changing the name on the bank account or the investment account to add the trust name. Again, you're not losing control, because remember, you're the original grantor, you're the original trustee, you're the original beneficiary. So you maintain control, but now that is contained within this box, within this container called a trust. Now, if after the lawyer creates and drafts the agreement, you don't change the name on the bank account, you don't change the name on the house, you don't change the name on the financial accounts, well, now it's not in the container, it's not in the box. And now you're going to have a jurisdictional issue, and we use that nasty word that people don't like to say, probate, which I know we'll talk about later on, to handle those affairs. But if it's named in the trust, that asset, that bank account, you become sick or pass away, the document says, here's who's to take over and here's what they're supposed to do. I'd like to tell you it's more complicated than that, but it's not.
Okay, but people really need to keep up on it. Like, what if you change the name of, a recipient on it? I mean, you kind of you have to keep up on it.
Well, it depends. I like to say there's three stations in life of estate planning. One of the young marrieds, your focus then is your kids. And God forbid something happened to you, who's going to raise your children? You may have a starter house, but your assets are certainly not what they are at the next second level, where I find clients coming in, where those kids are 20s, 30s, maybe they're ready to take over, maybe they're not. You've accumulated some assets, same objectives. How am I going to take care of my family or kids? And then that third stage, those clients in their 50s, 60s, and 70s, well, now their kids are grown. More often than not, after the husband and wife, those children are now named as backup trustees. Those children are now named as backup powers of attorney. And here you go. It's more life changes that cause the documents to get changed or updated versus law changes. I get a lot of calls from clients saying my documents are 20 or 30 years old. I go, that doesn't mean anything in of itself. Has your life changed in the last 20 or 30 years? That's what drives the train, so to speak, to consider updating or amending your documents.
Right. Okay. So that all makes sense. So, all right, you've already alluded to this, but how do your heirs avoid probate? Because you don't want this to end up in probate court. You want to handle it all yourself.
My answer is I have to confess a prejudice because I am also a probate practitioner. I practice regularly in all the local Michigan and Arizona now probate courts. It's not as bad as you'd think. On the other hand, it is something you'd like to avoid because it adds a layer of bureaucracy, a layer of compliance that can be avoided. How can it be avoided? Making sure there's beneficiary designations or titling to the trust, as the case may be. For example, you may have an IRA or a 401k. You want to name someone as a beneficiary. You pass away, it goes to the beneficiary. You don't name someone, well, now we get to that nasty word you just mentioned called probate. You name the house in the trust. You name the financial account in the trust. You have payable on death accounts. You may have life insurance. My preference is name all of that in the name of the trust. It's in one box. It's in one place. It's in one container. It's easier to administer. I do see clients come in and they've got joint bonds with their grandkids, and they've got beneficiary accounts, and they had when their kids were young, they had payable on death accounts. Things are scattered. When things are scattered, now it gets harder to administer. Now things can slip through the cracks and you end up in the probate court. So I lean and prejudice and leaning towards naming things in the name of that trust, unless there's a palpable reason not to.
Okay. It's very good advice. Tell us, if someone creates a living trust but does not properly fund it, then there's the possibility of it ending up going into probate. So what do you mean by funding it?
Funding it, retitling it, naming the trust, they're all synonymous. Getting the trust name on that particular asset. I once or twice a year have clients who have passed away and the kids in the family contact me, and there's an asset. Like I used a voting example in Florida a few years ago. There's a loose Chad. There's an asset out there that's not in the container, that's not in the box, that's not in the name of the trust. And the trustee, therefore, whether it's your wife or your children, they can't get to it because it's not in the name of the trust. It's in the name of the person who passed away, who's no longer around to access it. Well, now you need a court order. This has become a little interesting tidbit on this area, which is evolving, is digital assets. When someone doesn't leave passwords. And you think about it, well, that's not really an asset. I don't have to retitle that. But if the trustee doesn't have that information, well, they don't have jurisdiction over that either. Another reason why you go to an estate planning lawyer versus online. Our documents are up to date. When HIPAA changes, guess what? We change our documents. Cryptocurrency comes into play, guess what? We talk about digital assets now in our documents. There's another good example. A lot of people are getting into crypto or NFTs. Better make sure it's in the name of the trust. Otherwise, when you pass away, how's your wife and kids going to get to it? Because they're going to have to go to probate. And I've had a probate, a young person, tragic death in college. They were in their early 20s and everything was online. And of course, they didn't share that with their parents. Guess what we had to do? We had to go to probate and probate that
Wow.
particular asset.
Yeah.
It happens. It doesn't happen a lot, but it happens.
Right. You really don't think about that so much, somebody in their 20s, but now with all the digital currency and the NFTs and everything, that it's coming into play now.
More so now than ever. I like to point to this and tell everybody everything is on here nowadays versus paper. And we're moving more in that direction now than ever. Mm-hmm. That being the case, you have to be vigilant to make sure it lines up with what the law requires be lined up, to make sure you, your wife, your husband, your children, your beneficiaries can access this stuff. Otherwise, you're right, you're going to have to get a lawyer like me to go into probate court, which can take 6 months, a year or longer, adds a layer of expense, adds a layer of compliance, and also eliminates privacy. That's another thing about trust I didn't mention before. They're private. You sign them in a lawyer's office and your wife can look at it at their kitchen table. You go into probate court, guess what? Your nosy neighbor, your friends, they can all look at what's going on and know all your assets and all your bills and all your business. That's the other reason why you want to avoid probate, is the privacy issue that living trusts, revocable living trusts provide.
Yeah. Huh. Interesting. Yeah. And then maybe people don't think that, probate court, yes, it is very public. It's like on the record. So explain various powers of attorney. There are many kinds of powers of attorney, right? Some are good the date they're signed. Others require determination of incapacity. What if your mother is incapacitated? I mean, what do you do?
Well, first of all, if absent an estate plan that includes powers of attorney, you're going to probate court. People default thinking probate court, that's what happens when people pass away. You look at the probate court docket these days, and I'm not talking just here in Oakland County in Michigan or in Phoenix, Arizona, nationwide. There's as much, if not more, living probates going on, guardianships and conservatorships, because people are living longer than ever before. More so than decedents' estates, because people are getting hip to doing these living trusts and avoiding that probate process. The what you see on television, the reading of the will, that's on television. That's not real. On the other hand, if you don't sign powers of attorney for medical, if you don't sign powers of attorney for financial, and I'll explain the differences in just a second, you're asking for living probate, guardianship and conservatorship. And the same issues as I mentioned before, decedents' estates, applies to living probate, guardianship, and conservatorships. Costly, compliance, time, and lack of privacy. If you do a power of attorney, a durable power of attorney, a general durable power of attorney, it's a kitchen sink power of attorney. It covers every legal right you can have, except two. One, you can't give the power of attorney to someone to vote in the voting booth for you, at least yet. It may change someday. And again, we've heard of these voting issues coming up, particularly with the last presidential election, so who knows where that will go.
Right.
But that's where the law stands today. The other thing that's not in a general durable power of attorney is the HIPAA and medical. Because of compliance challenges, whereas 20, 30 years ago, practitioners like myself, we would combine it in one document. Now we separate it in 2 or 3 documents merely to satisfy the compliance folks out there, which are continuing to run our world day in, day out. Now, to finish answering your question, a general durable power of attorney can be good the day it's signed. It can be good conditioned on 2 or 1, depending on what the document says, treating doctors asserting that the patient can't handle their affairs. Mm-hmm. You also can have a hybrid of just what mentioned, kind of what I explain to clients like a Dairy Queen. You can get a swirl, a combination. Whereas the general durable power of attorney is vanilla, good its day it's signed, and many clients want that with their spouse. Makes sense. They want chocolate. They want the doctor involved if it goes to the next level, whether it's children or other people. Hence, a
Right.
hybrid power of attorney can be prepared and oftentimes is. So it's up to the clients. It's not a cost factor. They cost the same. It's a personal issue, kind of like vanilla and chocolate.
Right.
What flavor do you like? Is
Yeah.
what flavor we can provide. And again,
So, yeah. So this is all something, you can guide people on this, obviously your expertise in this is, is what you do. We've run out of time, actually. Great information. Lastly, how can people get a hold of you?
well, you can call our office here in Southfield and Bloomfield, in 248-593-5000. You can go to lipsonneilson.com online. And we also have the subsidiary, the Center for Estate Planning, ceplaw.com. I'm available any which way you can find me.
Okay. Well, we thank you for your expert advice. We always do. And we will also next be talking about probate court. So our viewers, we thank you for joining us on Gracefully Graying. Check out our website, gracefullygraying.com, our social media platforms, and our YouTube channel. And Steve Malach from Lipson Neilson, we thank you very much for joining us.
Thanks for inviting me. See you next time.
Okay.